April 10th was Equal Pay Day, created in 1996 by the National Committee on Equal Pay. And on April 10th, Westchester County Executive George Latimer, with members of the Board of Legislators looking on, signed into law the Wage History Anti-Discrimination Bill. It was unanimously passed by the county legislature and makes it illegal for an employer to ask prospective employees about their salary history. The idea is that such questions are discriminatory and help keep people stuck in low-paying jobs. The law takes effect 90 days after signing.
This is local law, intro number 10624 of 2018, passed by the Board of Legislators of the County of Westchester by 16 votes for and 0 against on the 9th day of April 2018, certified by Sunday Vanderburg, Clerk of the County Board of Legislators, and I fix my signature on this the 10th day of the month of April 2018 as County Executive, making this the law of Westchester County.
Yay!
What would Latimer say to those who question the need for another government rule affecting businesses?
The interference is non-existent. What you're dealing with are people who will go through an interview process. They will ask numerous questions about a candidate. They decide that they want to offer the candidate a job. They establish what that price is for the job, and that's the offer made. The ability to ask about their salary history is made illegal by this action, but it doesn't make impossible all the other questions that goes into making the hiring decision. So I would say if somebody said that to me, I'd say that's a non-issue. That's more about ideology than it is about practicality. I've been involved, as I've said, personally in the hiring process, and there's no necessity for me to ask a person's past salary history. I know what the job is budgeted for, either in the private or the public sector. If the person is the right person for the job, and I think they're the right person, we make the offer at a price within the range that we can afford. They can reject it or accept it. It's irrelevant, really, what they received in the last job, if they're qualified for the job that you're offering them.
The enforcement is with our Human Rights Commission. We actually made the 90-day window because we wanted to work with the business community, including the Business Council and the County Association, along with our local chambers, in order to let people know about this change. When we spoke to business people, we didn't see that there was a significant objection to it, but they wanted to make sure that people knew about the change. With larger companies, there's typically human resources or legal counsel that keeps up with labor changes, but we wanted to make sure that small businesses knew about it as well. The Human Rights Commission will enforce this. We gave them broad leeway to set penalties, but we really believe that most people understand this legislation. It is a very simple measure, and if a company were to violate it and the Human Rights Commission explained to them, don't do that again, we believe that we're not going to have a problem with compliance. We think that people will be willing to do it pretty readily.